Well, hello everyone, and welcome to this, the latest cost chat between friends, hosted by Practico. As usual, you have Laurel and Hardy in the form of Andy Ellis, the Managing Director of Practico, and me, Jeremy Morgan, retired cost silk and consultant to Practico. And our guest today, we're delighted to welcome PJ Kirby KC, or KC, oh God, show my age. Right. Of Gatehouse Chambers, a well-known cost specialist who shares with me the history of having been a solicitor before moving to the bar, and thus knowing far more than anyone else about costs at the bar. A brief preamble about the recording of this. The recording will be available on the usual online sites, and a summary will be made available to those on Practico's mailing list. That said, I just want to give you a brief preview of what we're going to be discussing. The first thing is the recent Court of Appeal decision in Belsner and Cam. Now, those of you who know that this is a decision about RTA cases decided on the portal, but you do commercial law, don't run away. There's some interesting points in it for everybody. There's an important discussion about the future of the Solicitors Act in a way, and about the distinction between contentious and non-contentious business. And PJ will be considering also the implications of this decision for commercial cases. There's a related case called Karatic about how you value a bill for the purpose of the Solicitors Act success or failure. We'll also look briefly at an upcoming decision of the Court of Appeal, so we won't be able to say what's in it, but just to give you notice that there is a decision due in the Court of Appeal before too long about whether a third-party funding agreement is in fact an unlawful damages-based agreement. So it looks at the definitions of what is a damages-based agreement. And finally, a thought expressed by Lord Justice Burse at a recent conference of cost lawyers, which is, should we do away with detailed assessment altogether? Something that causes panic among the three of us and many of our fellow colleagues, but hopefully won't come to pass. Anyway, over to PJ, and starting off with the case of Belsner.
Thanks very much, Jeremy. Just a couple of points on what you said. Firstly, yes, I did used to be a solicitor, but when I came to the bar back in those days, they had the sort of old-fashioned senior clerk who said things like, in the days when they called you sir, and he'd say, oh, sir, you used to be a solicitor, you'll know all about costs. And I thought, well, no, I didn't, because someone else dealt with the costs. It went off to Andy or someone else. But that was my intro into the world of costs at the bar, just because I had been a solicitor. The only other point I make just at the very beginning before dealing with Belsner is that the forthcoming case in regard to third-party funding and whether they are DBAs is in fact the Supreme Court, not the Court of Appeal.
Sorry.
So as high as we can go on that one. Yeah, so far as Belsner, one of those cases where no getting around it, I came second. In the Court of Appeal, we were representing Ms. Belsner, and it was an appeal by the solicitors arising out of costs claimed under the portal. But as Jeremy has said, there are points of general importance, not just for portal claims. This claim, which was for all of about £300, ended up taking 5 days of the Court of Appeal's time in front of the Master of the Rolls, the Chancellor, and at the first 2 days of the sitting, Lord Justice Arnold, and then when we reconvened in October, Lord Justice Nugee. So, as they say, a strong bench. It was obviously a test case. What it was testing was the somewhat, to some of us, obscure section in the Solicitors Act, section 74(3) of the Solicitors Act, and the extent to which costs in the county court would be limited to the sums that are payable by the other side. Now, as I said, I used to be a solicitor, but back in the 80s, I guess, I can't pretend that section 74.3 was something that I took great notice of when I was practicing in litigation in those days. And to some extent, it was emasculated by the fact that in those days there were scale costs, just showing how old I am, and that therefore the costs that were recovered from the other side were, there was still a discretionary element. So they weren't fixed costs, they were within a scale and you could go beyond the scale. But what has come about by reason of the introduction of fixed recoverable costs is that there is a fixed amount that is recovered in certain actions, and that includes matters under the road traffic portal and road traffic accident portal. So section 74.3 would, on the face of it, limit the costs that you can recover from the other side to those fixed recoverable costs under the portal, unless, and this is by reason of the provisions of the CPR, unless there was a written agreement between the solicitor and client allowing the solicitor to be paid more than the sums that were recovered under the portal. And so the case got to the Court of Appeal by a fairly long route. There'd originally been an assessment of costs by the regional cost judge, then gone on appeal to Mr. Justice Lavender. Mr. Justice Lavender had decided that the solicitors would be limited to the fixed recoverable costs, but his basis for deciding that was that he decided that the solicitor owed a fiduciary duty to the client to explain to the client that the fixed recoverable costs in this case would only be £500, and that if the solicitor hadn't explained to the client that the costs that the solicitor was wanting to charge the client was significantly in excess of that, then that was a breach of his fiduciary duty to the client. The Court of Appeal decided eventually, and I'll explain some of the history in a moment, the Court of Appeal decided eventually that fiduciary duty had nothing to do with it, and also decided that section 74.3 had no application anyway, because the Court of Appeal decided that despite the fact you had to bring a claim within the portal, that did not amount to proceedings in the county court. And it was only if you got to what's called stage 3 of the protocol that there were proceedings, because it was only then that you actually had to issue a claim in the county court, as opposed to having to follow the protocol. Now, the protocol is subject to certain provisions of the CPR. It's a procedure which, in effect, you've got to follow. And is obviously a modern way of dealing with things. And indeed, the Master of the Rolls is very keen on protocols and very keen on sort of computerized using IT with regard to the resolution of disputes. So he was very interested in this matter from the word go. Now, anyone who has suffered from actually watching these hearings, both in February and October, and I dare say it's a good cure for insomnia, but anyone who's actually watched the hearings will have noted a complete volte-face on the part of the indications given by the Court of Appeal between February and October. In February, the Master of the Rolls was saying that this distinction between contentious and non-contentious costs was absurd. If my opponent, who was Ben Williams KC, if Ben was right, then the whole thing had to change, because this was just an absurd way of going about things. The Chancellor raised a particular point, a point that I'd considered with my instructing solicitors and thought was a bad point, but I thought, well, he's raised it, so better go with that. And then on day 2 of the hearing in February, as I say, by that stage, the Master of the Rolls had given certain indications which I thought had gone too far, and which were unfairly put to Ben, and I was thinking, how am I going to deal with this when I'm on my feet? Because I can't actually support some of the things that the master roles have been indicating. But day two, it would appear, following further written submissions overnight and possibly following discussions with Lord Justice Arnold, who had perhaps taken a slightly different view, the court came in and said that they'd realised that this had far greater implications and far more importance than perhaps they'd first appreciated. And there were a number of issues that they wanted covered, and could we go away and come back later in the year, which is what we did. And at that point, the Court of Appeal's view was very different. And it was me who was on the receiving end of certain difficult points that were being raised by the Court of Appeal. It's not done, by the way, to simply say, well, it wasn't my point in the first place. You raised this back in February. That's probably not one's best advocacy in the Court of Appeal. So what has the Court of Appeal actually decided in Belsner? Well, first of all, this distinction between contentious and non-contentious costs. And the Court of Appeal has decided, what I guess was in fact the traditional position anyway, that unless and until proceedings are actually issued, you are dealing with non-contentious costs. Now that actually means that if you settle a matter before you issue proceedings, then so far as the costs between you and your client are concerned, that those should be assessed as non-contentious costs and not as contentious costs. What difference does that make, you ask? Well, that's one of the things we're going to be finding out over the coming weeks and months in the light of the decision in Belsner. But the main difference is that under the solicitor's non-contentious remuneration order, costs are assessed, they have to be fair and reasonable. It's not just reasonable, they have to be fair and reasonable. Now that's an additional requirement to costs that are being assessed, which are contentious costs, which have to be reasonable. So I can envisage, well, I can certainly envisage plenty of arguments that the requirement for those costs to be fair could mean that you could have perfectly reasonable costs, which are nevertheless unfair. And that could bring in, for example, the question of costs under a portal, or where there is a case, where there is a matter that involves fixed recoverable costs. Because if you haven't told your client that certain costs are not going to be recovered from the other side, or have led your client to believe that most of those costs will be recovered, which indeed was the position under the CFA in Belsner. But at the end of the case, you only recover a fixed amount, and that fixed amount was always known because it's set out in the rules. Then, whilst the costs that you've incurred may well have been reasonable, they may not be fair. I can hear some of you say, well, is that any different from the test effectively in Master Cigars, which is what is the sum that it's reasonable to expect the client to pay? And I can see that to some extent this may be fair, may be an element of reasonableness anyway. But that's where we are in the light of the Court of Appeal decision. Unless you've actually issued a claim form, there are no proceedings. You're therefore dealing with non-contentious costs. There is a question mark as to whether, for instance, you can have a gross sum bill in relation to non-contentious costs, or whether you have to have a detailed bill. I'm not sure too many cost judges are going to give that argument too much weight, but it's certainly something that's got to be determined. But there's also, bear in mind, if you're dealing with litigation, and if you're, for instance, dealing with litigation under a CFA, and the matter is resolved before proceedings are issued, does that mean that that CFA is in fact a non-contentious business agreement? In which case, can the client challenge the recovery of costs under the non-contentious business agreement? Can you suggest that that non-contentious business agreement itself is unfair? So there are plenty of points that are going to arise in the light of the Court of Appeal's decision. One of the other things, I mean, the Court of Appeal was critical of quite a number of players in this matter, fortunately not me, but was critical, first of all, not a player, but of the Solicitors Act. The Solicitors Act and the distinction between contentious and non-contentious costs, the Court of Appeal said that's illogical, it needs updating. The Solicitors Act itself needs updating. It was critical of the solicitors who were the successful appellants in the case, because what they had said to the client in the CFA and in their client care letter, they had said a case of your type will normally settle at this particular point. And if it settles at this particular point, we think your likely damages are going to be £2,000 or £1,500, whatever it was. And if it settles at that point, we would estimate that our costs would be £2,500 plus VAT, plus disbursement. You've then got buried away in pages and pages of information, as we often see, bits that say that you will be able to recover some, or in some places it said most, if not all of your costs, or in other places it said, you know, the court will determine what costs you should recover from the other side. Nowhere do they say to the client that whilst we have estimated, well, whilst in our view, your case will probably settle at this particular point, you'll probably recover this particular amount of money. At no point do they say, and the costs at that point would be £500 plus VAT. So they've given a net a cost estimate of 2,500, which is 5 times the amount of the fixed recoverable cost. Now, as it happens, the solicitors at the end of the case, what they the amount that they took from the client's damages was the success fee based upon, if you like, the big bill, either the bill for 2,000 odd. And that was then capped at 25% of the particular damages. And so they deducted from her damages a sum of 380 odd, I think it was, pounds. Whereas if they had had a success fee of 15%, because that is what they had agreed would have to be the success fee. The CFA itself had claimed 100% success fee, but on the detailed assessment, they accepted, in light of the case of Herbert, the most that they could probably get would be 15%. Had they only got 15% on the £500, then that would have been £75. So this is why we were arguing about a difference of £300, because the difference between £75 and about £380, because of the sum against which the success fee was to be calculated. So the solicitors
can I just ask,
yeah.
Do you think they'd have been better off if they hadn't given the client in the client care letter an estimate of their own costs at the stage the case was likely to settle? Because it was having done that their failure to say how much you might get back at that stage in inter partes costs became absolutely a glaring contradiction. If they just said, oh, we can never tell in these cases, we don't know when it'll settle and how much it'll cost, would they have been any better off?
Well, of course, they'd be obliged in terms of their regulatory obligations to provide the best information they could with regard to costs. And that's why the Court of Appeal was criticising them. So they were subject to considerable criticism because they were not giving best information with regard to costs. I mean, at the end of the day, it wouldn't have made any difference on the facts of this case, because they did cap their costs at effectively the amount that was recovered from the other side, but by then calculating their success fee on the larger sum. So it didn't really make any difference. I mean, I think to suggest that they'd be better off by not putting in the cost assessment. I think the Court of Appeal would still have said that they should have told her what the sort of recoverable costs would be. And Jackson, of course, in his report, I mean, he actually said that, or Justice Jackson actually said that, you know, one of the things you should be able to say to the client is, well, here's a grid. You know, if you recover this is what you'll recover by way of costs. You know, if you recover this by way of damages, this is what you'll recover by way of costs. And that it's not that difficult to do that. One of the arguments that have been raised, certainly before Mr. Justice Lavender, it wasn't really pursued in the Court of Appeal, was that, oh, it's all too complicated. But it's not actually all that complicated to show what the figures would be. I mean, I mean, it wasn't just the solicitors who were criticised. My instructing solicitors, who were check my legal fees, came under considerable criticism. But I mean, and in the words of Mandy Rice Davis, I would say this, wouldn't I? I thought somewhat unfairly, because their business model was criticised for bringing these claims, which are all for modest amounts. I think possibly the Master Rolls might refer at one point to trivial amounts. Well, whether an amount of money is trivial or not rather depends upon how much money you have in the first place. If you are a person who doesn't have very much money, £300 is not trivial. If you're someone who might be able to spend £300 going out for dinner, then perhaps it is trivial. And I accept, obviously, that in the scheme of things, when you look at the legal costs involved, it may be trivial. But the solicitors who were bringing these claims, so check my legal fees, who were bringing these claims, they were bringing them in the High Court, but there's a good reason for that, is that was the only place they could bring them. So to criticise them for bringing the High Court seems to me a little unfair. The alternative, which is what the Court of Appeal suggested in both Belsner and, in a sense, in even more forceful terms, perhaps in Carrickage, was that these matters could be brought more economically and more efficiently in the legal ombudsman. Well, there was no actual evidence as to the legal ombudsman ability or capability of dealing with these claims. And the prospect of the legal ombudsman now having hundreds of these sort of small claims seems to me a little worrying, because the legal ombudsman record, which is published every year in a report, is not that great in terms of the timescales in which matters are dealt with. And I think it's also fair to say that matters in relation to solicitors' costs are not particularly straightforward. Dare I say it in this recording? Yes, I dare. That perhaps the Court of Appeal's views, which changed between February and October, themselves illustrate the fact that an understanding of solicitors' costs is not entirely common to the whole of the legal profession, let alone to unqualified persons who are going to be dealing with the original complaints to the ombudsman. I am aware of a recent matter where the ombudsman appears to have refused a complaint with regard to an unwritten damages-based agreement. Well, you can't have an unwritten damages-based agreement, and yet a complaint with regard to that appears to have been dismissed, certainly before it's gone to the next level. And so the Court of Appeal saying all these matters should go off to the legal ombudsman. I am worried about that, because I'm not sure that clients will actually get a fair and proper consideration of their bills there. And this is, I mean, it's not as if this is a sort of new entitlement. I mean, the right of a solicitor, right of a client rather, to challenge their solicitor's bill by way of what in the old days was called taxation and now assessment, goes back literally hundreds of years. And it was a way in which, officers of the court, where their bills were considered, and because there was, historically there was always consideration that the relationship between the solicitor and client was one that was subject to particular duties and particular concerns, and a particular concern about undue influence, etc., that it was right that a client should have the right to have the bill considered by a judge. And what appears to me to be one of the consequences of the Court of Appeal's decision in Belsner and indeed Carrickage is that right to have the bill considered by a judge has to some extent been lost. It hasn't been lost, but the Court of Appeal has suggested that you should first of all go off to legal ombudsman.
But they also, I mean, in terms of sanction, it doesn't sound as though they thought they could say the court should refuse to accept these applications for assessment on proportionality grounds, and that would be quite a major step to effectively undermine a piece of primary legislation. But they did suggest that you wouldn't get your costs even if you were successful in doing so, therefore, or thereby undermining the model of your professional clients.
Yeah. But just on that point, Jeremy, if you obviously primary legislation deals with the 1/5 rule. So in effect, it's the Court of Appeal saying, well, this is special circumstance.
Yeah.
But where do the special circumstances kick in? If it's a £300 bill, it's might be said, it's disproportionate to the how many proceedings, but if you're having to bring the claim in the High Court because of, again, primary legislation, where's the cutoff point? Where's the point where you can say, yes, I can have my bill considered by the SCCA? Is it £5,000? Is it £50,000? Is it £100,000? Bearing in mind you're in the High Court. So they are. There is certainly what appears to be a restriction on clients' rights with regard to challenging bills. Strictly speaking, the bits about legal ombudsman, etc., are overturned. But if you're a district judge sitting in your local county court, you're going to take very serious notice of what the Master of the Rolls says, and quite rightly. And clearly he said it because he wanted this to be the way in which these matters are dealt with in the future. I mean, also you've got the problem that if you go to legal ombudsman makes a decision. It's not binding on the client unless the client accepts that. Well, if, as appears to be the case at the moment, cases before the legal ombudsman are taking up to a year. If the case is all about monies that have been deducted from an award of damages, that probably amounts to payment of the bill. If it's 1 year on, you're too late to challenge the bill anyway. When do you actually issue your claim? Do you say to the ombudsman, hurry up because I'm about to run out of time? Or are you effectively then stuck with the ombudsman's decision?
But I mean, I may be wrong with this, but my recollection is that the ombudsman is not strictly bound by legal to apply legal principles, but more sort of what's fair and reasonable in the view of the ombudsman.
You're absolutely right. You're absolutely right.
So that makes it even more complicated when you do, have quite important legal issues at times.
Yeah. And also the ombudsman, as it happens, I think within about a week of the decision in Belsner, announced that they would now be imposing a 1 year period for the bringing of complaints. So, as I say, if they're then taking 10 months, 12 months, whatever, to decide matters, assuming you bring your claim before the ombudsman within that year, the chances are that you will be out of time. If you then disagree with the Ombudsman's decision, you'd be out of time for them bringing a claim to the FCCA.
One other thing, sorry.
I was just going to mention, because it seems to me this is very important for all solicitors in whatever area of practice. The Court of Appeal disagreed with Ms. Justice Lavender's consideration of fiduciary duties, and the Court of Appeal made quite clear that obviously, while solicitors do owe fiduciary duties to their client, they don't owe a fiduciary duty with regard to the negotiation of their retainer. Obviously, you could, within the negotiation of a retainer, impose something that amounted to the solicitor receiving some sort of secret profit, and that would be breach of fiduciary and any other number of duties. But generally speaking, in negotiating the terms of the retainer, at that point, you don't owe a fiduciary duty to the client. And that was another reason why the appeal was allowed. So the appeal was allowed primarily because the, Section 74 didn't apply anyway, because these were not proceedings in the county court, because they were non-contentious costs. But in any event, the basis upon which Ms. Justice Lavender had found in favour of the client that the fiduciary duty was owed, and that not to explain to the client the difference between the recoverable costs and the costs that they would be charging, was a breach of that duty. But as I say, no such duty was in fact owed at the point of the negotiation of the retainer.
That's actually the point I was going to say. It is a general application and really quite interesting. I don't think it's a totally novel point, but it's very useful to have it spelled out in the recent and authoritative decision. But the idea that the client has no reasonable grounds to believe that the solicitor is not looking after his or her own interests at the point when they negotiate a retainer is actually rather an important point.
Yeah, indeed it is. Yeah, so we're all going off to the legal ombudsman now, and I hope they've recruited lots of more people to help them sort out these matters. That's
the other point, isn't it?
Well,
how many staff have they got?
Yeah, I mean, and the point you were making, Jeremy, about they're not actually obliged to follow strict legal principles. It's going to be very interesting. Are we going to get a judicial review of a legal ombudsman's decision? Or what's going to happen when a client says, I disagree with what the legal ombudsman has offered, and you then go off for a Solicitors Act detailed assessment? Is the court at that point, presumably the court can't turn around and say you should have gone to the legal ombudsman? Because the client would say, well, I did go to the legal ombudsman. I didn't like what he or she said. And that's why I've now brought this matter. And the court. But
you could also get, couldn't you, clients who are concerned about the costs of detailed assessment going to see the legal ombudsman in the hope of a sort of nice, friendly, warm and cuddly decision from this nice person who doesn't apply too much legal principle, to get the bill reduced to much larger cases than these very simple RTA portal ones.
Indeed.
And that's a bit of a scary thought for solicitors generally.
Yeah, and I mean, one thing that the legal ombudsman, or certainly other ombudsmen I have dealt with, they will also sometimes award £200, £300, £400 for distress or the upset caused. It would be interesting to see whether they ended up being the tariff with regard to solicitors' costs of whatever nature, as you say, whether they're portal, whether they're commercial, whether family or whatever. So Belsner is probably not the end of the road, but it obviously has dealt a very significant blow to people like those who were instructing me, who are seeking to challenge bills in that way.
I can't ask you this question, but I will. What is the future of their business model?
Well, they'd have to answer that themselves, but according to the Master of the Rolls, it can't carry on because that's effectively what he said. And I have no doubt that not that I've been asked to advise on it. I've no doubt that they've read the judgment and taken advice on it, or taken that into account.
But wouldn't it have always been isn't it just a step on the road to reform? I mean, it might take a long time to reform, but even the check my legal fees business model is that way too, isn't it? I mean, you know, if it's a call to action from government and those that advise them on legislation to tidy up and modernise the Solicitors Act, and while we're at it, have a different way of resolving disputes between, certainly a quicker and cheaper way of resolving disputes between solicitors and clients about their fees, then that's the work that needs to be done, and everything else is it goes into the pot, doesn't it? You know, including like, should the legal ombudsman get involved, and you know, once you've got well, if we ever get to the point where there is a simpler way of resolving these disputes, then the sort of cases that check my legal fees would prosecute, they fall away anyway, don't they?
Yeah. I mean, obviously, in the light of the judgment in both Belsner and Karadzic, the Court of Appeal made absolutely clear that the Solicitors Act needs reconsidering and needs amending, or just completely reworking. I mean, that has been said quite some time by judges in the SCCA. Whether this government or the next government is going to have the time or the inclination to get involved in the Solicitors Act and a complete rewriting of it remains to be seen. I mean, they ought to, because it is wholly illogical. It doesn't fit in with all the new portals they want to introduce with regard to all sorts of claims, and it's not fit for current purpose, because although it's the Solicitors Act 1974, believe it or not, is 48 years ago, but the Solicitors Act itself was simply a repeat of earlier Solicitors Act, so that's why I said earlier it goes back hundreds of years, and a lot of it really hasn't changed in that period of time.
I suppose one risk of this decision is that if the Department of Justice took the hint and said, all right, well, we do need to do something about reforming the Solicitors Act, there might be a whole carve out of lower value bills, trivial in the view of the Master of the Rolls, and say, well, they can be dealt with by the Ombudsman. In fact, a whole lot of stuff might be referred to the Ombudsman under new powers, which would possibly be problematic for the reasons we've discussed.
I'm not sure I've ever really got to the bottom of a sort of chicken and egg argument that has come up a few times on detailed assessment between the parties, which is that if there's the prospect of a solicitor and a client, or a client may be challenging what they don't like about their solicitor's fees, haven't they got to get rid of all of that before you have a between the parties assessment? When really the client wants to say, let's have the I'll say that I'm kind of liable for it, just to get us over the line of having a detailed assessment, and I'll make up my mind afterwards as to whether I'm going to have a go.
And what happened? Yeah, I agree, Eddie. I've never actually really, I expect Jeremy has, but I've never really had to argue that, because if the indemnity principle bites, which of course it does, what does happen on a solicitor and client assessment if subsequently the costs are assessed at a lower amount than the amount you even recovered?
Exactly.
I can't remember. I've had that discussion for sure.
I've had the discussion. I've never actually had the argument. But one day someone's going to have that, and there'll be a problem.
I mean, you can have it separately about elements of success fees now that are not recoverable. Because that's irrelevant. But of course it's not irrelevant if you. It's not, well, it is irrelevant, but it's irrelevant to between the parties assessments now, isn't it? For the most part. We've still got
interesting enough, just going back to Belsner, at the end of the case, that obviously the Court of Appeal decided that the bill in any event had originally been assessed on the wrong basis, because it had been assessed as if it was contentious business, whereas in fact it was non-contentious business. The Master Rolls then proceeded in his judgment to do an assessment of the bill, which funny enough came out at the amount that the solicitors had received. So he assessed the bill at the £500 being the recoverable cost, but assessed the success fee again based on the larger amount. I mean, we weren't going to go off to the Supreme Court seeking to challenge the Master Rolls summary assessment of those costs, but it does seem to me there's a certain illogicality there. But
I mean, it's
he was acting as an ombudsman.
Well, he was probably in the light of the judgment doing the right thing, but whether it's susceptible to criticism is. I mean,
it struck me that, and I mean, it's only speculation on my part, but the reason that the solicitors didn't pin their CFA on a CFA-like sort of system or matrix or what have you, was in a way to keep their options open, because if they knew about the success fee, because they want to find a way of keeping their options open to make sure that they can at least get 25% of the damages.
Yeah, and some certain cynical people might think that under some of these CFAs, that the particular hourly rates, etc., are such that whatever the outcome of the case and whatever stage it settles at, that the solicitors will always, as a matter of course, receive 25% of the general damages and past specials. And it will be capped at that. Success fee will be capped at that, but it will always be that.
We'll reach
and you almost have. I mean, I have argued this. I think you almost have in a sense, it's a disguised DBA. So it's effectively the model of a lot of claimant solicitors of these small claims. Is that they will limit their costs in effect to what is recovered from the other side, including disbursements, plus 25% of damages. But calculated by reference to a success fee based upon hourly rates, etc., etc.
Having raised the spectre of DBAs, perhaps we should move on. I mean, Belsner is a very important case, and hopefully we've demonstrated to the wider audience the importance of it in general terms. But there is a Court of Appeal. No, sorry, Supreme Court.
Supreme Court.
I've got this note here which says Court of Appeal. Supreme Court is about to consider whether a third-party funding agreement is in fact an unlawful DBA. Can you tell us anything about that?
I can tell you a bit about it. I'm actually in it, so
that's a help.
Well, hopefully I know a bit about it. I mean, this is going from one extreme to the other in terms of size of case. So this is a multi-million pound claim in the Competition Appeal Tribunal. So hundreds of millions of pounds worth of claim as opposed to £1,000 personal injury claim. Some of you may be aware that in the Competition Appeal Tribunal, in order to get appointed as the representative for a group action, you have to show that you've got sufficient resources to pay your own costs, and that you've got sufficient resources to pay adverse costs if you're ordered to pay them. And in this particular case, I'm for a number of buyers and hirers of trucks who are bringing claims against truck manufacturers for there's alleged cartel with regard to the prices at which the trucks are sold. One of the truck companies has taken the point, not the others, but one of them, it's PACCAR, which is in fact DAF trucks, which you'll probably be familiar with on driving up and down the motorway, have taken the point that the claimants who are funded with a third-party funding agreement with one of the well-known third-party funders, a member of ALF, the Association of Litigation Funders, a third-party funding agreement is in fact a damages-based agreement, because the argument is that when one looks at the definition of litigation services, that it includes the provision of financial assistance in relation to the making of a claim. And a third-party funder, we will accept in front of the Supreme Court, is obviously providing financial assistance in relation to the bringing of a claim. And so what PACAR says, well, in which case you fall fairly and squarely within the definitions of litigation services, and you fall fairly and squarely within the definition that is therefore covered by the damages-based agreement regulations. Now, if that's the case, then the evidence on behalf of the Association of Litigation Funders is that all litigation funding agreements by the major players for the last 15 years have all been contrary to the DBA regs and would all fall within the definition of a DBA. The impact of that on current litigation, not only in the Competition Appeal Tribunal, but large commercial litigation, would be extraordinary, because it would suddenly be found that the litigation funding agreements were unlawful, unenforceable. What do you do about that litigation that's already completed, where the clients have paid 30, 40, whatever % to the funder under an agreement which it would turn out was unenforceable? The argument was rejected by the Competition Appeal Tribunal, and Justice Roth was the chair of that. It was then rejected by, and this may be where the confusion about the Court of Appeal came in, it was rejected by the Divisional Court, which was also sitting as the Court of Appeal if necessary, because there was an issue about the jurisdiction to hear an appeal on this point from the Competition Appeal Tribunal. They decided they didn't have jurisdiction as the Court of Appeal, but could deal with it as Divisional Court. They then gave a leapfrog certificate to go straight to the Supreme Court. Supreme Court, they didn't give permission, but a leapfrog certificate. The Supreme Court then took about 13 months to decide that it would give permission for the appeal. The appeal is going to be heard on the 16th of February. And the Association of Litigation Funders are intervening. There's which the Consumers Association are wanting to intervene just in writing. And Professor Mulheron is wanting to intervene in writing, because she and Nick Bacon, King's Counsel, who many of you will be very familiar with, she and Nick drafted proposed amended DBA regulations, which in fact sought to put this argument to bed, because it had been recognized that this argument could be raised, albeit that she and other commentators had described the argument as hopeless. But the proposed amended DBA regs would have meant it was completely unarguable. The only trouble is, going back to the point we were talking earlier about amending the Solicitors Act, Ministry of Justice hasn't taken up these draft amended regulations, which came out, I think, in October 2019. And they still sit there, and indeed the indications are they're not going to introduce them. So
well, it's not only just now, because actually when the DBA regs were in draft, it occurred to me that there was this possible argument, and you could sort it by clearer wording, and representations were made, I shan't say who by, but to the Ministry of Justice to amend the regulations before they were even made into law, to get rid of that potential argument, and ignored. Absolutely.
Yeah. So now, there is hundreds and hundreds of millions of pounds worth of funding out there in relation to current claims, and goodness knows how many hundreds of millions of pounds in relation to already determined claims, which is, possibly all been done pursuant to unenforceable agreements.
You might need a new sort of concept like they have in the European law of an appellate decision which only takes effect in relation to the case before it and maybe future cases, but isn't backdated decisions which have already been made. But that would be novel.
Well, that would be very
English
novel.
law.
Yeah.
But otherwise, yeah, the skies will fall in, won't they?
Yeah. So no pressure there then on that case. I'll be sleeping well on the night of the 15th of February. Maybe I'll go out for a belated Valentine's Day. So that's going to be very interesting. The appellant's statement of cases, written case, is due on, of all days, the 22nd of December. So that then gives us a great Christmas and New Year to consider it before we have to respond to it. We have been given a further 7 days, so we haven't got to do it by the 5th of January, which is what we were originally required to do. Just got to do it by the 12th of January, so no problem.
Fantastic.
Yeah.
Given that people always feel whatever time they're given, that ruins your Christmas anyway, even with another 7 days, doesn't it?
Well, that's right. I mean, in fairness, I guess we know what their arguments are going to be.
Yeah.
So in fact, we're at the moment drafting bits of our written case, and hopefully it will be a bit of a cut and paste job over Christmas.
Well, that will be a fascinating decision. It really will. But moving on, final point as we contemplate the legal horizon is, are the days of detailed assessments numbered? They might be if Lord Justice Peirce has anything to do with it.
Yeah, it's interesting, isn't it? I mean, Jeremy, you and I have been doing costs for quite a long time, and you were obviously the godfather of the law in relation to costs and the cost bar, very much so.
In a benign way.
And you kind of think that, there was a time when you could see in authorities your references to barristers arguing about costs as if it was a bit of poo on the bottom of your shoe and really shouldn't be something that barristers, the bar, should be concerning itself with. I mean, that my concern is, are we moving again to a situation where we really don't want to be troubled with these things about costs? Costs is not something that the bar should be dealing with. Costs is not something that should be taking up court's time. And yet, at the end of the case, a client who has incurred X thousand pounds worth of costs is going to want to recover as much of that X thousand as they can. And will understandably feel that justice is not done if they get X thousand divided by 4, i.e. a quarter of X thousand. After all, the dispute may have been for less than that. Now, obviously, I accept that costs often run away in terms of the size. Obviously, I accept that clients need to have some greater idea about what it's going to cost them. But my concern is that we may be moving again to a situation where the courts are saying, sort out your costs somewhere else and don't darken our doors with these highfalutin arguments about costs and what they should be and what technical arguments there should be in relation to them.
I completely agree. And I think one of the problems, and this is where Ripper Jackson was really good, he nailed this point and said, in so many cases, the costs are at least as much and very often more than the value of the underlying subject matter in a case. And you cannot just relegate that amount of money, that proportion, if you like, of the value of a case to 5 minutes at the end of, at the end of a trial. And if you then say, well, we'll make it 10 minutes and we'll summary assess the costs in those extra 5 minutes, you are not doing justice to anybody, because you are removing any element of certainty that there is in the current position.
Yeah, yeah. I mean,
I wonder who, you know, I read the, you know, with all the caveats about, you know, we're only seeing a few selective quotes. I wasn't at the conference that he spoke at. But nevertheless, you know, the idea that, you know, he hasn't spoken to anybody who's given him a really good reason for thinking why it should stay as it is, you know, or the difference between budgets and estimates and why there really is a difference. Well, I wonder who's been speaking to, really. Because there are, well, the one that sprang out at me is, well, you're going back to arguments about whether there should be summary assessment as opposed to detailed assessment on the assumption that all cases end in a trial. And there's going to be a judge at the end of it that's heard everything and is going to be able to make a decision. Well, the vast majority of cases don't finish that way. So where are you going to go? And I mean, I may be wrong on this, but the idea of whether you could just use the cost estimates that you give to your client as the cost budget for the case, well, normally they happen a lot earlier than they're required to for the purposes of budgeting. So I don't know whether that works. Now, I'm not saying status quo. You know, I mean, I think he was he seemed to be training his sights quite a bit on the costs of detailed assessment of costs.
But such a small number of cases in any event go to do that. I mean, how many times have the three of us been at a detailed assessment where a solicitor, a well-experienced solicitor, will say, I've got to tell you, PJ, this is the first detailed assessment I've ever had. Now, I've had that on a number of occasions from partners in city firms, or indeed when they've come to me, they've said, I've never done a detailed assessment. Well, I don't criticize them for that. I congratulate them for that because they sort them out. They sort out the costs. So the detailed assessment cases are few and far between in terms of obviously the number of cases that are concluded.
Yeah.
I don't know where we're going.
I mean,
I noticed also that he raised this in front of the ACL. I think it was that was the conference he was speaking at, but he didn't have the nerve to raise it at Practico's breakfast meeting where he was a guest, because he knew that was a weighty audience that would have shot him down.
He just said he would have. Well, yeah, he was already getting some stick for barristers ex-barristers making decisions about costs when they don't really know anything about it. He was, if you recall, wasn't from us.
But you see, this is an old point, and it still really gets me, which is, back in the day, a lot of barristers would say, "Oh, I don't know anything about costs," as if that was something they were almost
as if that's something to be proud about. Exactly.
Proud of. Well, no. If you're a barrister representing your client, you should know about costs, and you should at the very least, know the basics. But it's almost as if the current judiciary are from that stable. Some of them are from that stable that said, "Well, I don't really know anything about costs. Costs is not something that I ever deal with."
Exactly.
And therefore haven't liked cost budgeting, and now don't like the thought that the costs have to be assessed by some means or other.
Yeah, I mean, it's moved down. I mean, there was years ago the Supreme Court said we don't really want to be dealing with costs. The Court of Appeal is the place to deal with it. Now the Court of Appeal say we don't want it either. It should be somewhere else. And really, where does it go? It's
Ombudsman.
Yeah, well, sorry, I don't want to look back at that particularly. But no, and I think it's unfortunate. And I'm all around, I'm sure some people will be trying to look for their very smallest violins, if they're going to be worrying about our futures. I understand all of that, but nevertheless, why don't they just accept that a lot of this is to do with the squeeze on judicial resource, and this is just a part of that. And it's horrendous. Not only are there, several, there's a big difference between the standard of access to justice you get in the Rolls building compared to your local county court, and we've discussed that on previous editions of this discussion as well. But likewise, they seem to the snobbishness aspect of it, that it's almost, it's a bit gauche to be talking about money. seems to me to be just completely wrong. And I don't think that that's a very modern view either.
No.
No.
I can understand bringing in more fixed costs for certain levels of cases.
Yeah.
I can understand that. I would have, for say larger cases, I would have thought budgeting has actually helped with regard to dealing with costs at the end of the case. I mean, obviously that was intended to, and I would have thought to a reasonable extent it has. Now, yeah, a lot of judges have not enjoyed doing cost budgeting, but yeah, you won't find many cases in the SCCO or anywhere else where parties have been particularly successful in saying that there should be a departure from the cost budget.
No, exactly, and also, you know, you've only got to look at the number of detailed assessments that settle before they get to court as well.
Yeah.
So in the wider world, people are getting on with resolving their disputes about costs in the commercial world in a proportionate way, because, you know, the ultimate clients have got no interest in spending money on matters of principle. At all.
No, I mean large corporate disputes, commercial disputes. I mean, the solicitors there undoubtedly resolve the cost without it going off the detailed assessment.
Yes, exactly.
Anyway, I think we can sum this up by saying, Lord Justice Belsner, it may be some time before you get invited back for a bacon sandwich at Practico's breakfast meetings.
You may get back. You may be invited back to be cross-examined. We'll see.
Anyway, I think that's it.
We can't finish without one thing, Jeremy.
Well, that's over to you then, Andy.
Well, look, I've heard that you had a very pleasant day out the other day. So tell us all about it. And as they say, some football managers, you know, show us your medals. They show us your medal.
The medal is actually, I should have got it out. I'm sorry. It's in the safe because it's so valuable. No, this, for those who are remotely interested in this, it's a great time to switch off for most of you. But I got an MBE for the campaign that we fought for British citizens in Europe and European citizens in Britain after Brexit to try and conserve our rights. It probably suggests that we did a lousy job, because if we didn't upset the government enough so that they gave us MBEs and some of the others got OBEs, we can't have fought very hard. But I think we take it the other way, which is at least we had a very effective campaign, and we engaged at the right level and used the right degree of assertiveness, but not going over the top to try and get the rights we did. But it was a fascinating campaign, and I think really important, and there are still issues arising, as I told the King.
Yeah, I'm sure he was interested. You're not allowed to talk about what I take it. You're not allowed to talk about your discussion with the King, are you?
I don't know. I got a wonderful picture of me sort of gesticulating. You know, I live in Italy now, so the hands come into these things like this too. But no, it was a nice day. It's a lovely day. It's like, I'm PJ. It's very just like taking silk. You know, everyone's nice to you. It's not often that everyone's nice to you in your life, but everyone is. And I was not alone. There were 90 people getting awards the same day, including, and I didn't see her, was Emma Raducanu, and I was really upset not to have seen her. But there you go.
Yeah. Well, congratulations, Jeremy. Well deserved.
Thank you very much.
Congratulations.
Yeah.
on that note, anyway, I think that's the last of these chats for this year.
It will be.
And sorry, I'm getting overcome by coughs. I hope everyone has a good Christmas break, apart from PJ, of course, who'll be deep in submissions for the Supreme Court. But we wish you all very well, and see you again next year.
Thank you.
Thank you very much indeed.